All right, our second question will be directed toward Judge Blitzman and Judge Bryant. The opioid crisis in Massachusetts has had a tremendous impact, as we all know, on the court system. I'd like to direct the judge's attention to a C&P hearing where one or both of the parents have had substance abuse issues, possibly with alcohol, these days more likely with drug or other substances that they have become addicted to. What can counsel in those cases, whether the counsel for a parent or a counsel for the child, or even the counsel for DCF, consider in C&P proceedings to get the parents meaningful treatment for drug or alcohol addiction in their efforts to regain custody of a child? Judge Blitzman, would you take the lead, please?
Thank you. Gladly. And good afternoon. It's great to be here with such distinguished colleagues and such a wonderful audience. So the opioid crisis is just that. It's a crisis, but to sort of frame the conversation, drug abuse, drugs are not a new issue. It's sadly ironic that it took the opioid epidemic to sensitize the general population about issues that have plagued other communities, although perhaps not in the context of opioids, for generations. So many of the communities that we interact with, drug abuse is not a new issue. Some of this affects race and class, to be quite blunt. 70% of the cases that we hear in care protection cases involve allegations of neglect. Many of them are characterized by substance abuse as opposed to overt allegations of abuse. The through line of all these cases is public health. If we continue to employ a reactive ad hoc crisis solution approach to addressing this issue, we're going to continue to spiral downwards. We've seen an increase in juvenile court filings in our child welfare cases in the care protection context of approximately 42% since this crisis has become popularized and well known. It's placed a great strain, of course, on court personnel. Many of you who are involved in litigating these cases are similarly stretched. But as is often the case, what we need, again, is an orientation where people can access services proactively before there's court intervention. So one thing you could do when you are in court, though, is to really be sensitive and learn about what community-based services are out in the regions where you live in. I would urge every one of you as advocates to be aggressive in filing motions for funds pursuant to the Indigent Cost Court Act, Chapter 261, Sections, Chapter 261, which enables you to get fees which would put you in an analogous position to a person who could retain counsel. So you file a motion, you ask funds for a social worker who could help identify community-based services. One of the sad things about deinstitutionalization is when we started closing institutions, locked facilities, there was an assumption that the money was going to go into a robust continuum of community-based care in a variety of contexts. This didn't happen. We closed the institutions, but we never invested in the so-called continuum. As a result, we've been playing catch-up ever after. This issue, by the way, affects not only the child welfare cases, but affects juvenile justice cases as well. I draw your attention to an article which was recently published by the Columbia Social Justice Institute. Vinnie Schiraldi, formerly at the Kennedy School, has moved to Columbia with people like Lael Chester. Lael Chester was a former director of Citizens for Juvenile Justice, worked at the Kennedy School with Vinnie, is now working at Columbia. Their research is really, really concerning. They're looking at the effects of opioid use in juvenile justice and criminal justice population. It turns out that the rate of opioid deaths has increased by 350% since the year 2000. 25% of the fatalities which affect the 18 to 24-year-old cohort group is attributed to opioid abuse. So what does this mean in terms of juvenile justice and criminal justice? And obviously it's plagued parents who, as well as Jay's question at the top indicates. Well, when we talk about drug courts in the juvenile court, at least, when we start considering concepts such as raise the age legislation, juvenile court drug courts are designed to address co-occurring disorders, mental health disorder as well as substance abuse. Often the substance abuse is a manifestation of untreated mental health. We've all heard about self-medication, etc. The district court drug courts dealing with a similar age group tend to focus more on the substance abuse. So that's something to think about. I know there are different positions that have been taken about raising the age legislation. So I would urge all of you to think systemically. This issue affects not only child welfare cases, it affects juvenile justice and criminal justice as well, and it affects everyone from birth through age 25 at a minimum, and obviously significantly thereafter. So those would be my initial responses to your question, Jay.
How much do you think is an appropriate amount for counsel to ask for in order to retain a social worker to guide him or her on the treatment options for the client who is a parent?
It's a good question. Given the increased sensitivity to this issue and other issues regarding court costs, we've promulgated policies which will enable in some of our courts, Middlesex County is one, where you can get up to $500 ex parte without going in front of a judge for that type of service. I signed off today, I think, on a set of 4 for one attorney who had 4 different families whom she was involved with in the context of both delinquency and care and protection cases. Now, for monies in excess of that, and when there's a more sophisticated need, for example, if there's an issue of forensic analysis, obviously those are things that will go in front of a judge. By the way, my role, I believe, as a jurist is not to say, no, you're not entitled to the money. It's just to ensure that the money is reasonably related to a court event, is necessary for the preparation of a defense, and all we look for, I know all I look for, and I think my friends here feel similarly, is just some indication of what the fee schedule is going to be. But this type of service, I think, is axiomatic. Those of you who work for the Youth Advocacy Division or for CPCS, you have in-house social workers, but for those of you who are advocates, and as Ken indicated, we all know the overwhelming majority of our clientele are indigent, don't have that in-house service. So again, you should be in the same position as a YAD or a CPCS or a CAFL attorney should be.
In the federal court, motions for funds for an indigent client are automatically handled ex parte. In the Superior Court, I can only think of one instance in the last 10 years where a judge denied my motion for an ex parte hearing on a motion for funds. Any advice on how the lawyers should present an ex parte motion for funds?
Well, the key is, I think, to have an affidavit that spells out a motion and an affidavit which detail the need and the range of the fee. Obviously, you're going to be citing Chapter 261, Section 27A through G. That's the statutory citation. We have a mechanism now that they could be filed in our clerk's office. You bring it to the clerk's attention. If the clerk feels it can't be handled, or he or she thinks there's some issue, they'll bring it to the judge's attention.
And finally,
by the way, just in response to your comment, the Commonwealth under DCF has no standing to object. Again, this Independent Court Cost Act should be looked at as an equal protection statute. And again, one of the issues that permeates this conversation implicated by the preceding, bail conversation is making sure that we don't have either in bail class-driven detention because people can't afford bail, or and in this context that they're in a position to adequately present a defense, and the lack of money should not preclude that.
Let's say a well-off parent has developed a substance abuse problem. Let's say it's alcohol, and the child is taken away from that parent because of that alcohol abuse problem. That parent has all the incentive in the world and usually funds to begin getting treatment. How about an indigent parent? Would you think it's appropriate for counsel to seek funds for outpatient treatment or even inpatient treatment for an indigent parent who needs to get that problem under control if they're ever going to have a chance to get their child out of foster care?
Well, it's a provocative question.
Well, that's what I'm here for.
It's a provocative question. We're judges. We're not litigants. We're not advocates for either party.
Just answer the question, Your Honor.
I'd have to take it on a case-by-case basis, but I think in some situations it might be appropriate, and it depends whether or not that parent is involved with the DCF. If the person is involved, if the parent's involved in the Department of Children and Families, and there's a service plan, for example, which talks about getting appropriate substance abuse, and I think this is something you all experience every day. You can't find an appropriate service provider, you can't pay for the drug screens, there's not an appropriate service. Well, maybe you should file an abuse of discretion motion alleging that, or asserting that the department is acting arbitrarily and capriciously in promulgating a service plan, which is a non-starter definitionally, because the financial conditions of a parent precludes cooperating with that service plan, notwithstanding good intent.
Judge Bryant, how has the opioid crisis affected your proceedings in your court? And in particular, how do you deal with that crisis regarding parents who obviously need services?
I assume it's affected it the same as it has everyone else. I think the issue with respect to substance abuse is the main issue is reducing the risk so that you can get the children home. If the goal is to reunify, you have to remove whatever risk there is because of the parent's substance abuse. One of the things I wanted to piggyback on something that Judge Blitzman spoke about was community resources. And one of the things that I wanted to encourage was that if you are representing clients, knowing what's out there in the community, and in particular into their communities. And it might take putting aside some biases you might have. But one of the things I wanted to recommend or suggest that I've seen is that looking to churches. Just about every church for people of color, certainly in black churches, linguistic minorities, they run substance abuse groups, or they have parenting classes, things that aren't on the DCF radar. But certainly if you're waiting for something for for a DCF referral to come through or for an opening, I think it would make sense to take advantage of all of those resources. Most likely it's not your client that knows about them, but maybe your client's grandmother or mother knows about them because they're probably the ones that's actually going to the church. A lot of them are run by people who are professionals, but in their spare time or their ministry time, they run these, and I know of many of them. And I think, we have a bias because it's something that's church-run. But from my perspective, if you come back to court at, motion status and your client, they have their Bible in one hand, but they have 10 clean urine screens, that's all you should be caring about, is that they are actually doing something. And I think that that's strong evidence. Likewise, organizations like MAPS, if you're a Portuguese speaker, or seeing what they have. In most immigrant communities, my parents came to this country, it was the church that told them where to bank, where to go to school, where to live, those types of things. So don't overlook those as places that offer support. I don't think you can just sit back and rely on a referral from a well-intended but a very overworked social worker, and what she has the same list as everybody else. And so just kind of thinking outside the box to provide your evidence that the client is actually getting some treatment. Also, that there's an alternative to foster care in these situations. It's about the risk to the child. And I think I'm seeing a little more of this from the department in terms of safety planning. Before they remove right away, I'm seeing that they tried to safety plan. They tried to find the relative who can move in or something like that. Well, I don't think it's just on the department to do that. Even after the child's removed, maybe there's a change that you can present based on some resources that are out there in the community that would make it safe for this child to be back around the parent.
How would you respond to someone who says that it would be inappropriate to refer someone to a church-based program because the court is endorsing a religious approach to treatment?
I would say then that person should just wait for the opening in the programs that they've been referred to. I'm not talking about imposing religion on anyone. I'm saying that if you have a client for whom part of their community, and for most, and for many, I should say, communities of color, the church is a repository of resources. Civil rights movement came out of the church. So if it offends you to the point that you couldn't represent someone, then you just wait for what DCF is offered.
I'd like to ask you the question I asked Judge Blitzman. How amenable are you to acting on an ex parte motion for funds that would authorize money to be spent on a parent for treatment of an addiction?
I think I have the same answer. I think it's a case-by-case basis, and I think it depends on what that treatment is, what the particular circumstances of the client. Is it something that can't be afforded any other way? So a very detailed affidavit and information about what this particular thing is. I think there are probably some circumstances where that's appropriate. There are probably circumstances where, depending on the client's situation, is the client a person with a disability? Is the client a person who's, there's some particular type of treatment that works for this particular type of person? I think all of that I would take under consideration.
Does a lawyer have a better chance of having a motion for funds allowed if the affidavit is very specific regarding what organization would be providing treatment or what individual would be providing treatment, as opposed to a general request for funds, say, made close in time to the first appearance of the case in the court, when they're just asking for money, and then they're going to, if the money is allowed, then they will find someone? Or does it make a difference?
I think having taken the time to find something specific for your client that demonstrates you have an understanding of what the client needs, that the usual list that they're going to get from the social worker isn't going to work, I think there's a lot more justification for allowing that than just something general, because I just think there's a lot more justification for something specific that perhaps can't be replicated any other way, but you've really taken the time to figure out what your client needs, and this is available, and we need this.